Good day, Crime Talk aficionados. It's Saturday. That means it's time for the weekly recap of all the top stories throughout the week here on Crime Talk, conveniently located in one location. I hope you enjoy. Watch the video. We'll see you next time. First on the docket, things are about to get real interesting in the Alex Murdaugh case. Alex Murdaugh's attorneys have failed to convince a United States District Court judge that any further release of their client's jailhouse calls would be considered a violation of federal wiretapping laws. Well, the court's order denies Alex Murdaugh's request for a preliminary injunction and now puts the ball in Richland County's court to make good on its promise to release the calls upon this very decision. Now, the jailhouse calls were released earlier this year and directly contradicted statements made by the attorneys that said Mr. Murdaugh was broke. In a 20-page order issued on June 1st, United States District Court Judge Cameron McGowan Curry denied Murdaugh's request for the preliminary injunction. Murdaugh's attorneys filed this lawsuit in the United States District Court based upon leaked jailhouse tapes. That's because the South Carolina Freedom of Information Act allows for the release of inmates' phone calls, which are recorded. Inmates and the individuals that are receiving the calls from the inmates are clearly made aware that their calls are being recorded. In fact, Murdaugh reminded family members several times during the calls that they were being monitored. Murdaugh's calls were also cited in the South Carolina Attorney General's memo in opposition to Murdaugh's request for bond reconsideration in January. Now, the vast majority of inmate calls would be of limited interest to the public. It is clear that the Murdaugh case is a wild exception, particularly as it relates to transparency. Judge McGowan Curry notes that her order is based solely upon Murdaugh's attorney's federal wiretapping law argument that Murdaugh was not seeking relief for the Freedom of Information Act request. She mentions that the calls might be exempt from release under state law, which in part allows for the non-disclosure of law enforcement information that would deprive a person of their right to a fair trial. However, it would be difficult for the attorneys to claim this exemption based upon their own nationally televised admissions of their client's guilt, where they said that he basically stole millions of dollars from clients and his law firm. Now, the argument under the federal law was that anything regarding a tapping of a telephone line needs to be approved versus Title III of the federal wiretapping statutes. The court completely rejected that argument, basically saying the Murdaughs and anyone else in the jail are clearly warned that these can be turned over to law enforcement. In this particular case, the Freedom of Information Act allows that the tapes be turned over to the public. That was the problem that the Murdaughs had, saying that, yeah, we know the police would be listening, but we didn't know it would go out to the world that these calls could in fact be released. Now, take it from somebody that has listened to a lot of jailhouse calls over the years. Most of these will be boring. Some will be completely embarrassing. And there'll probably be lots of admissions. And what does this prove yet again? It probably will show that no one ever listens to their attorney when the attorney advises them, do not talk about the facts of your case or your case on the phone in the jail with anyone, because anything you say can and will be used against you. Somehow people only think that what is actually stated to law enforcement is the only thing that can be used against them. No, that is not the case. Anything a defendant says, as long as it's relevant, can be used against him in a court of law. People don't seem to get that, including jailhouse calls. I think things are going to get real interesting, because when are people most candid? Well, when they think no one is listening, or at least when they think no one's actually going to want to listen to my jailhouse calls. So things are going to get good in the Murdaugh case here real soon. I can't wait to hear a lot of these calls. Camille Vasquez. Remember her? Of course you do. She was the young associate working on the Johnny Depp trial. Well, now you can just call her partner. That's right. Camille Vasquez was promoted to a new role in her law firm following the success in the defamation trial against Depp's ex-wife, Amber Heard. The Brown Rudnick law firm wrote in a tweet, "We are pleased to announce that Camille Vasquez has been elevated to partner." She was a key member in the litigation team that won a jury verdict for the actor Johnny Depp in his defamation trial against his ex-wife Amber Heard. And according to the press release issued by the law firm, Ms. Vasquez joined Brown Rudnick's Orange County office in 2018 as an associate in the litigation and arbitration practice. She has more than 10 years of experience as a trial lawyer in high-stakes disputes, including defamation cases, contract disputes, business-related torts, and employment-related claims. Now, William Baldiga, chairman and CEO of the Brown Rudnick firm, says, "We are delighted to welcome Camille to the partnership. Historically, we have reserved this announcement for the end of our fiscal year, but Camille's performance during the Johnny Depp trial proved to the world that she was ready to take the next step now. We are incredibly proud of her and look forward to what she will accomplish as our newest partner." So what does that really mean? Well, it means now that she gets to pay a share of all of the overhead expenses. Now, if there is any profit at the end of the year, she'll get a piece of that versus just her salary and maybe a bonus. But more than likely, that's right, Camille was probably getting a lot of people asking her if she wants a job, so the firm jumped in and made her a partner. Congratulations. Makes you wonder what the buy-in was, because you don't just become partner and one day they give you, a percentage of something. You got to pay for it. Well, guess who thinks they had an excuse for everything? Todd and Julie Chrisley. The reality TV stars have been found guilty of running a year-long fraud conspiracy and hiding their money from the Internal Revenue Service. A federal jury in Atlanta convicted the couple on Tuesday, who now could face up to 30 years in prison. Now, Todd Chrisley was found guilty of conspiracy to commit bank fraud conspiracy to defraud the United States, and tax fraud. Julie Chrisley found guilty of conspiracy to commit bank fraud conspiracy to defraud the United States, tax fraud, wire fraud. The two have been married for 26 years and share 5 children together. The family is best known for their reality show, Chrisley Knows Best, which started in 2014 and is currently still on the air. Chrisley's former CPA, Peter Tarantino, was also convicted Tuesday, and he was found guilty of conspiracy to defraud the United States and willfully filing false tax returns. The Chrisleys were initially indicted back in August of 2019, and a new indictment was filed in February of this year. Their trial began about 3 weeks ago, and prosecutors alleged that the Chrisleys submitted fake documents to banks when applying for bank loans. They also alleged that Julie Chrisley submitted a false credit report and fake bank statements when trying to rent a house in California, and then the couple refused to pay rent a few months after they started actually using the home. The couple apparently used a film production company they controlled to hide income to keep the IRS from collecting unpaid taxes owed by Todd Chrisley. Now, during the trial, it was revealed that Todd Chrisley had a gay affair with his business partner who helped him commit the fraud before tipping off the cops after their romance soured. Mark Braddock, who had to tell his own wife about the affair before testifying, turned the Chrisleys into the FBI for tax fraud and told the jury he did not want to be talking about his affair. Braddock has also been granted immunity since he got to the authorities first. After the affair ended, Braddock claims an anonymous source sent text messages threatening to expose the relationship and his boss's fraud. Todd Chrisley and Braddock ended up paying the blackmailer $38,000, which Braddock withdrew from the bank in 4 $9,500 payments before meeting Todd Chrisley in a parking lot. He handed over the large amount of cash in a little bag for Todd Chrisley to pay the blackmailer, and he testified during the trial. Chrisley's lawyer, Bruce Morris, accused Braddock of thinking he was Todd Chrisley and had an obsession with the guy. Braddock has denied these claims. He also said the only time he'd been with a man was with Todd Chrisley. Well, after they were found guilty, United States District Court Judge Eleanor Ross allowed the Chrisleys to remain free on bond. The judge placed them on a GPS monitoring and home detention, meaning they can only leave the house for certain reasons, including work, medical appointments, and court appearances. Just goes to show you, first one in gets the best deal. Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Britney Spears' wedding was dramatically interrupted when her first husband, Jason Alexander, crashed the big event. Jason apparently went live on Instagram as he approached the event's security. Now, in the video, he's claiming that his first and only wife, Britney, had invited him. Jason showed public support during the Free Britney movement, in which she was in a conservatorship. Back in 2020, Jason Alexander went to a rally for Britney and told the paparazzi he was in communication with his ex-wife, Britney Spears, and Jason Alexander were childhood sweethearts and tied the knot on a whim in early morning hours of January 3rd of 2004 at the Little White Wedding Chapel in Las Vegas. The marriage was annulled 55 hours later, which Jason Alexander later said was forced by Britney's mother and Britney's management. Jason Alexander says during his live stream that he was going to crash the event before there is some sort of physical struggle, and Jason's phone freezes up. Somehow, Jason was able to actually make it inside of Britney's home, where he continued to live stream. The Ventura County Sheriff's Department responded to a trespassing call. Britney Spears' attorney, Matthew Rosengart, said he is absolutely livid that Jason tried to crash Britney's wedding and said Jason should be locked up. Jason Alexander was booked for trespassing, vandalism, and 2 batteries related to physical altercations he had with Britney's security team. He also apparently has a felony warrant for larceny in another county and remains in custody. Now, before I get to the legal implications of crashing a wedding, be sure to subscribe and leave a comment. And remember, you can listen to Crime Talk anytime on any of your favorite podcasting apps. A person commits the crime of criminal trespass if they knowingly and unlawfully enter and remain in a dwelling of another person. This can also include that of a vehicle as well. But on a property, you can't go on a property unless you have permission, and that permission can be revoked. And if you are advised that your permission to be on the property is revoked, you can be guilty of trespass. Now, trespass is different than it is for a burglary. Burglary is going into the dwelling of another with the intent to commit a crime therein. So, if Mr. Alexander was going into the wedding with the intent to assault somebody, and nobody says he is, but if he was, then he could be also guilty of burglary. Now it's just a trespass. And depending on the location, a criminal trespass can be a misdemeanor, and it can also be a felony if it's trespassing in the dwelling, usually where people inhabit or the building is occupied. Obviously, it's less of a crime if it's an open field. We'll wait and see if Mr. Alexander bonds out and whether he accepts a plea or goes to trial.